Finally, this week we come to a discussion of major statutes, major criminal statutes used in the combating or the prosecution of organized crime. For the most part, we didn't have very, very strong statutes for a long time. It really wasn't until the 1960s that we realized that existing laws regarding or that were used to combat organized crime were ineffective at bringing down organized crime. And this is a realization that brought about the passage of things like the Omnibus Crime Control and Safe Streets Act of 1968 and the Racketeer Influenced and Corrupt Organization Act, popularly known as RICO, in 1970. Probably the most well-known, probably the most effective of the pre-1968 legislation designed towards combating organized crime was Title 18 United States Code, Section 1951 through 1955, popularly known as the Hobbs Act. Enacted in 1946, the Hobbs Act created some new federal crimes. It made, for instance, it made illegal the obstruction or interference with interstate commerce through extortion or robbery. It also made illegal the use of the travel on or the use of interstate facilities to aid illegal activities. And so the use of federal highways, the use of telephone and mail at the time. Today, you would include computers and the internet in interstate facilities or facilities used to aid illegal activity. And so, the Hobbs Act is still alive and well. Now, the Hobbs Act largely used to prosecute union leaders who would obtain kickbacks from using their influence over the union. But it is, and it still remains, a useful tool in combating organized crime, but it's not used as much, or not used very often, because RICO, which is the next act we'll talk about, is much more effective. Though keep in mind, Hobbs Act violations are included in the list of RICO statutes, including the use of crimes that can be used to be prosecuted under RICO. So let's talk about RICO for a minute. RICO is the Racketeer Influenced and Corrupt Organization Statute, passed in 1970, and is and still remains the most effective law enforcement tool for combating organized crime. And other than the USA Patriot Act, it is also one of the most controversial law enforcement statute ever passed. And the controversy surrounding RICO, if you thought the USA Patriot Act had questionable or things that or debatable issues with it, consider the following list of complaints about RICO from lawmakers, defense attorneys, and even some prosecutors. For instance, RICO is accused of being far too vague in its definition of organized crime, and I challenge you to look up Title 18 U.S. Code, Section 1961 through 1965, which is where the RICO statute is located, and see for yourself if you think that statute is vague. Remember, one of the requirements for a law to be constitutional is that it needs to be specific in what is prohibited. And so, leveling this charge of vagueness at RICO is to say that is to accuse RICO of being that it ought to be void for vagueness. Let's see if we can find here U.S. chapter, United States chapter code 1961, and I'm just going to read this to you from the code. You can look this up on the internet. I think you've looked at it before earlier in the semester, but if you look at the very first section of Title 18, where under RICO, you can see it says racketeering activity means any act or threat involving murder, kidnapping, gambling that goes on to list several crimes, which are chargeable under state law and punishable by imprisonment more than 1 year. There's the same definition of racketeering that we gave you the first week of the semester. Fairly vague. I don't know. It seems specific to me. You decide. And I'm going to let you decide that. But you can Google it if you just type into a search bar in Google. If you type 18 USC 1961, you'll get the RICO statute. Other complaints against RICO include that it might violate, some complain that it violates constitutional rights of freedom of association. Some say that RICO could violate the double jeopardy clause of the Fifth Amendment. Others say that it's either cruel or unusual, therefore violating the Eighth Amendment. Others say it interferes with due process or the individual's right to speedy trial. As you can see, there are numerous complaints leveled at this act. But what is it? See, maybe you can make this decision for yourself whether you think RICO goes too far. What RICO does is it allows the prosecution of organized crime leaders, because the leaders of organized crime groups, if you've looked over the semester, look at the organizational scheme used by organized crime groups, you realize that the bosses, the guys really in charge, are very much insulated from the actual criminal acts. These are guys that may be directing the criminal acts, but they're not actually committing the acts themselves, and they're so insulated by the chain of command that it's very hard to prosecute the leaders of mafia groups and Russian organized crime, or Yakuza, or motorcycle gangs. When the leaders don't actually get involved in the specific subjective crimes, it becomes hard to prosecute them. So RICO allows the prosecution for a pattern allows law enforcement, the government, to prosecute individuals for a pattern of crimes committed through organizations. They call it in the act, they call it criminal enterprises, or just enterprises. So what's the actual crime under RICO? Well, the crime under RICO is is to acquire or receive income from or operate, acquire, receive income for, or operate an enterprise through a pattern of racketeering, either directly or indirectly. The RICO statute specifies 32 specific crimes that can be classified as racketeering or activities for profit by organized crime. Committing any of these crimes through a pattern of racketeering, I'll explain pattern of racketeering in a minute. Punishments under RICO, and understand, punishments under RICO are punishments that are tacked on or added to the punishments for the other crimes. So if I commit two of these qualifying crimes, and again, I'll give you a list of some of those in a minute. If I commit two of those within a 10-year period, 2 to 3 of those in a 10-year period, let's say for the last one, let's say I commit several acts of money laundering, or maybe I commit a money laundering and some drug trafficking, and maybe another crime that's on the list. For those crimes, I'm going to, if I'm convicted of them all, I'm going to be, say I get convicted for those 3 crimes, I'm going to be sentenced for each of those crimes, and so I'm going to get the normal penalty under law for those crimes, and then on top of that, I'm going to be charged with a RICO violation. Which here is that double jeopardy complaint, whereas some people are saying, okay, you've already been charged for these acts, you're charged and convicted for these acts once, and then charged for them a second time as a group, as a RICO statute. And some people say, well, that's punishing the individual twice for the same acts. And they say, okay, well, that's Fifth Amendment double jeopardy violation. RICO has so far been upheld by the Constitution, by the Supreme Court. So anyway, if I commit these acts, so I get convicted for those things, I get the penalties for committing those crimes. Then, if I'm convicted under RICO, I may suffer up to 20 year. Well, I suffer a 20-year mandatory sentence, not up to 20 years period. A fine of up to $20,000. You're thinking $20,000 for a crime lord, big deal. But I also suffer the seizure of assets derived from my organized crime activity. And so everything the government can say, he got that property as a result of his participation in the organized crime activity, or as a result of these crimes, all of those things the government can seize through criminal forfeiture. It's quite a boon for law enforcement, because they can either keep the stuff seized and use it for their to further their investigations, or they can sell the property and keep the money. The civil section of RICO, and RICO does include both a criminal and civil section, allows the victims of organized crime to sue the defendants for triple damages and triple attorney fees. And so, imagine, I don't know if there's any money left over when the government's done getting their cut, but it's a huge penalty if you're convicted under RICO. So what is prohibited under RICO? Well, here is the 4 things prohibited under RICO. First is using income received from a pattern of racketeering or collection of unlawful debt to acquire interest in a business affecting interstate commerce. That's 1. Or 2, acquiring through racketeering or collection of unlawful debt interest in an enterprise that affects interstate commerce, so trucking companies, for instance. Third, conducting or participating through a pattern of racketeering or collection of unlawful debt the affairs of an enterprise affecting interstate commerce. So number 3 there is running an organized crime group. And then 4, conspiracy to do any of the first 3. So you're either going to use income received from a pattern of racketeering, acquiring interest in a business through a pattern of racketeering, or participating in a pattern of racketeering, or a conspiracy to do one of those 3 things will get you a RICO conviction, or at least a RICO charge. Now, what the heck is this phrase, pattern of racketeering? Because it's in all 4 of those unlawful activities under RICO. So what is a pattern of racketeering? Well, a pattern of racketeering is defined as any 2 acts of racketeering within 10 years of one another. They do not have to be the same crime, but they must be related by motive or purpose or design. But as a prosecutor, all you've got to do within this 10-year span of time is find any 2 crimes that are on that list of 32 that are related somehow by motive or design or purpose. And bam, you've got your RICO conviction. These acts can be things like, certain things on the list of 32 in the original RICO Act include things like Hobbs Act violations, Mann Act violations or white slavery, drug trafficking, arson, extortion, obstruction of justice, kidnapping, loan sharking, and among other things. And the list has been expanded. For example, in U.S. versus Terry in 1980, RICO was expanded to include publication of obscene materials, drug trafficking by street gangs, and police corruption. In addition to the criminal penalties, RICO also permits restraining orders to be placed against defendants to prevent them from transferring property that might be forfeited. Mafia capo can't transfer ownership of all his property to his wife to prevent it from being seized, or transfer the property to someone else to prevent it from being seized, because the government can put a restraining order preventing him from transferring that property. RICO also allows trials with multiple defendants, where evidence presented against one can apply to all of them, which allows you to prosecute an entire organization at once. you can load up the classroom. You can load up the courtroom with as many defendants as you can tie to the organized crime activity. Included in RICO is the forfeiture, is this idea of property forfeiture, which is a major, has a lot of controversy attached to it, and is a major boon to law enforcement. Now, there's criminal forfeiture through RICO, where the prosecutor has to prove that the property, the assets to be seized were part of the criminal enterprise. And in criminal forfeiture, you have to prove those things beyond a reasonable doubt. You have to prove that the individual who the property being seized from committed the crime. Civil forfeiture, which is also allowed under RICO, is a little different. Civil forfeiture is a legal procedure against property, not against a person, but against the property, and it's any property purchased with the profits from illegal activity and used, and then can be seized. Civil forfeiture, unlike criminal forfeiture, requires a lesser burden of proof. It requires preponderance of the evidence only. Another big difference between civil and criminal forfeiture is with criminal forfeiture, like any other criminal prosecution, requires that the state completely prove its case. Unfortunately for defendants, in civil forfeiture, the burden of proof shifts. As long as the prosecution can show probable cause that the assets to be seized or the property that's seized is related to a criminal enterprise, is related to a RICO crime or a RICO-related statute, then that property can be seized. That property, as long as you can show probable cause, then the burden of proof shifts to the defendant, and the defendant then must prove that they obtained that property through legitimate means. So, it's important. If you ever wonder why you keep receipts for things, well, that's it. If your property is ever seized, you've got to be able to prove. If you ever have property that's seized through civil forfeiture, you have to prove that you bought it legally, that you bought it with legal money. The government does not have to prove that you used illegal means to obtain the property. All they have to do is probable cause, and I can establish probable cause on this pen if I really wanted to. In addition, with civil forfeiture, hearsay evidence can be used. Remember, it's a civil matter. And so, in a civil matter, you can use hearsay evidence when you're establishing probable cause. Now, probably the good thing is property cannot be seized without notification to owners. So you do have to notify the owner, hey, we're going to seize your property, and gives the owner an opportunity to contest the seizure. Of course, that notification is going to also be accompanied by the restraining order preventing the transfer of the property. But it is important to remember that in civil forfeiture, and this is the last thing that I want to tell you about civil forfeiture, and I want you to make sure you get it. If you're taking notes, make sure you get it. Is that with civil forfeiture, it is a legal attack against a thing. It's a legal attack against the property itself, rather than a person. And that's important to note because since it's an attack against the property, the owner of the property does not necessarily have to be convicted of a crime for the forfeiture to take place. So let's say I arrest Joe Blow Mafia Don or Mafia Capo for drug trafficking, and then I establish probable cause that his house, his cars, all the money in his bank, most of his personal assets, I show probable cause that all of those things were purchased with money from his drug trafficking operation. Now let's say I lose the criminal trial, and my capo, he is acquitted. He does not necessarily get his money back, because if I've seized his stuff through civil forfeiture, he has to go to court and prove that he bought all that stuff legally. And if he can't prove that, even though he was acquitted for the crime, I, the government, still get to keep his stuff because of that shift of the burden of proof. And so everything he doesn't have a receipt for, everything that he can't show that he bought, he purchased with money legally obtained, I get to keep. And so even if this drug running capo gets acquitted, I still get to keep all this stuff, even if he goes free. Gotta love the law. Gotta love those laws. Okay. Other important things, statutes to talk about when we talk about organized crime. Certainly, money laundering statutes are of great importance because one of the easiest ways or one of the more effective ways to take down an organized crime group is to follow the money, so to speak. And there have been several statutes used in the criminal prosecution of money laundering. Probably the first one of importance is the Bank Secrecy Act of 1970. That would be Title 31, United States Code 5311. The Bank Secrecy Act requires financial institutes to file what's known as a currency transaction report, or a CTR, on any cash transactions of more than $10,000. Now, I think we've talked about this when we talk about money laundering. Because of that, organized crime groups try to avoid depositing more than $10,000 at any one time in the bank. But any cash deposits of more than $10,000 have to be reported. The Bank Secrecy Act also requires a currency and monetary instrument report, a CMIR, for any money transfers that go in and out of the United States that exceed $10,000. So that doesn't have to be cash, just any bank transfers or wire transfers in excess of $10,000 have to be reported. In 1986, Congress passed the Anti-Drug Abuse Act, Title 31 U.S. Code 5324, which criminalizes the practice known as smurfing. If you remember, smurfing is the process of having multiple people deposit amounts less than $10,000 into an account in an effort to avoid the Bank Secrecy Act. This requires a 5 to 10 year penalty for every person involved in the smurfing. And so you get 10 buddies to deposit $900 in your account, or 11 buddies to deposit $900 in your account, and then as a way to avoid the reporting requirement. That in itself is an illegal act. Continuing on money laundering statutes, the Right to Privacy Act in 1978 allows financial institutions to provide law enforcement with the name, account number, and nature of any, provide law enforcement with the name of the person or organization owning an account and the account number of any suspect transactions. So basically, the law says to a bank, if you suspect that a transaction is illegal, you have the right to pass on to the government. You have the right to violate the account holder's privacy and inform law enforcement of the amount of the transfer, the nature of the transfer, who the account belongs to, and the account number. Yay. Also in 1986, government passed Title 18 U.S. Code 1957, which is the Money Laundering Act. The Money Laundering Act made it illegal to engage in monetary transactions in excess of $10,000 with property derived from proceeds of acts specified under RICO. These penalty for violations of the Money Laundering Act include 20-year minimum, 20-year prison sentence, $500,000 fine, and civil and criminal forfeiture of assets. Yay! Let's see, what else you got? Drug Abuse Act of 1988 requires that offshore banks record any U.S. cash transfers in excess of $10,000 and requires those banks to allow the U.S. government access to their records. There were a pair of money laundering acts in 1992 and 1994 that criminalized operating a money laundering business, actually made it illegal to do money laundering as a profession. And the same acts protect financial institutions from civil liability for reporting suspicious activity. And so this is kind of a nice addition. The earlier laws gave the banks authorization to provide names and account numbers, and then the Money Laundering Acts in 1994 gave the banks protection from civil action. It also goes a step further than the earlier acts, whereas earlier acts gave banks permission to report suspicious activity. These Money Laundering Acts in 1992 and 94 actually made it a requirement to report suspicious activity. And then finally, in 1988, you'll see the Money Laundering Prosecution Improvement Act, which requires banks to verify the identity of anybody who purchases bank checks or traveler's checks or money orders in excess of $3,000. And I guess I shouldn't have said finally there, because the USA Patriot Act goes to great lengths to expand upon the requirements on reporting requirements on financial institutions. So you can see how extensive the law is for money laundering. Let's see, what else we know about? Conspiracy statutes, probably the next thing I want to talk about. Conspiracy statutes are sometimes preferable for law enforcement because they're easier and less complex than putting together a RICO charge. Conspiracy statutes allow you to prosecute the leaders of criminal organizations through conspiracy to commit whatever crime. And your textbook talks about conspiracy statutes. I just want to kind of outlay for you some advantages and disadvantages of the use of conspiracy statutes. The disadvantages are really simple. Proving conspiracy to commit offenses requires a long-term commitment to surveillance and evidence gathering. It is rather expensive and time-consuming to put together a conspiracy charge. And there are also issues, there are also political and logistical issues in dealing with the multi-jurisdictional investigation. But there are advantages. And I give you 5. The first advantage of a conspiracy charge is that the conspirators charged don't actually have to know each other, but all the conspirators are responsible for all the acts of the others, and statements of one can be used against the other. And so you get the guy at the top of the organization, if you can somehow tie him to the soldier and the crew, they don't have to know one another, but everything the soldier and the crew did, the boss can be held accountable for. A second advantage is that anything done to carry out the objective of a crime is what's called an overt act. These overt acts, these things that you're actually, because what you're proving a conspiracy charge is that each person charged with a crime of conspiracy has committed overt acts towards the furthering of a criminal offense. These overt acts do not necessarily, the overt acts themselves do not necessarily have to be criminal. And all the participants don't need to know or don't need to have knowledge of all the overt acts. They just have to be connected somehow. Third advantage, that all the conspirators, all the people involved, are responsible for the crimes of everybody involved. As long as they were a part of the conspiracy when the crime was committed, and that offense was committed in furtherance of the conspiracy. A fourth advantage is that a successful conspiracy case can be used against an entire group. So I don't just get the boss and the crew, I can get everybody in the chain of command. As long as I can show that everyone has committed overt acts towards furthering that conspiracy, I can get them all on the conspiracy charge. And the reality is, any evidence I use against any one of the people in the conspiracy, I can use against all of them as long as I can make those connections. Pretty cool, huh? Okay, final thing I want to talk about for statutes is Title 21 U.S. Code 840. 840, I think it's 840, is the Continuing Criminal Enterprise Statute, or CCE. This is something that strikes fear, just abject terror in the little hearts, the little pea-sized stony hearts of organized crime figures, because it is directed straight at the leader of organized crime groups. It is specifically directed at any person who occupies a position of organizer, supervisor, or manager in a narcotics production and distribution enterprise. The minimum sentence for a CCE conviction is 20 years without parole. That's the minimum. Maximum penalties range up to life without the possibility of parole and $2 to $5 million in fines, and all profits and assets are subject to forfeiture. Yeah, cool, huh? What do you need to do to prove continuing criminal enterprise? Well, there are 4 elements. First element that you have to prove is that the defendant has violated any federal drug offense. Any. That includes possession. Second, the violation must be part of a continuing series of violations. In other words, you have to prove 3 related federal drug offenses. Third, the defendant must be operating in concert with 5 or more people and occupies a position of organizer, supervisor, or manager. So it must be someone who is in a leadership position and working with at least 5 or more people. And then finally, the person must receive a substantial income or resources from the violations. So possession probably won't cut it. But if you can prove these 4 things, you can hit the individual with this CCE, this as being part of a continuing criminal enterprise. And again, these penalties, much like with RICO, these penalties are penalties on top of the penalties they might receive for the 3 related acts to begin with. As you can see, there most certainly are some effective and widespread laws and statutes available for the prosecution of organized crime. And along with the breakdown of the codes of secrecy and the attitudes and values of the younger generation of mobsters, these laws such as RICO and the CCE are major reasons why organized crime is much weaker today than it was in the past. All right, well, that's it for this week. I've decided to make this kind of a short video. I will remember next week is the final exam. Good luck on that. I know you all will do very well, and I will get your term papers back to you as soon as I can get them all graded. Just ask for your patience with that. All right. Thank you, and see you next week again.